today's video, I'm going to be discussing issuing an employee with a disciplinary inquiry notice. So this video can be helpful for managers, employers, team leaders, or supervisors, or anybody who needs to issue an employee with a notice to attend a disciplinary hearing. Or this video could be helpful for employee representatives or for employees who have received a notice to attend a disciplinary hearing and you'd like to get a better understanding of that notice. So welcome back, or just welcome if you're new here. I'm Carmen Fourie. I'm an employment relations practitioner and I'm also the director of Fourie Employment Relations. I've included a list of my credentials in the description box below to give you some peace of mind around the content that I share. My usual disclaimer, I cover a lot of information in these videos, but I'm not able to cover every single scenario or every exception to the rule. So therefore, these videos are for educational purposes only, and remember to contact a professional if you need to. I have linked my disciplinary notice template in the description box below. For a small fee, you can purchase that and then use that to follow along in this video, or just take whatever disciplinary inquiry notice you have and follow along in this video. Or if you don't have one, that's also okay. Just go along with the video and then make notes about what is important or what you want to remember regarding issuing a disciplinary notice or receiving a disciplinary notice. And just because I'm going to say the word a lot in this video, when I say disciplinary notice, I mean a notification to attend a disciplinary inquiry or a notification to attend a disciplinary hearing. I'm going to start at the most obvious place. What is the purpose of that notification? Because if we can understand the purpose, if you forget everything I say in this video or forget any of the finer details, if you can remember the overarching purpose of that notice, a lot of the time the things will just come to you instinctually, or they will just make logical sense to include it on the notice. So what is the purpose of a disciplinary inquiry notice? The first purpose that I can think of is that you want to notify the person to attend a disciplinary hearing or a disciplinary inquiry. Those words can be used interchangeably. They refer to exactly the same thing. A disciplinary inquiry is a disciplinary hearing. They're just different words. In order for an employee to attend this disciplinary inquiry, they need to know when it's taking place. So they need to know the date and the time, and of course, where it's taking place. The next purpose is that you are notifying somebody in advance. You're issuing them with a notice to attend a hearing, as opposed to simply walking out of your office and calling them into your office without any notification. The reason that an employee gets a notification in advance is so that they can prepare for the disciplinary inquiry. I will get to the time frame that you have to issue this disciplinary inquiry, but the most important principle that I would recommend keeping in mind is the purpose. That is, an employee needs to be able to prepare for that disciplinary inquiry, and that should give you an indication of what is the appropriate time frame. And then in order to prepare, an employee needs to know what is the hearing going to be about. And this refers to the allegations or the charges against an employee. So of course, that needs to be on the notification. I don't think these next things are vitally important, but I do think they are nice to have on a notification, and that is who is going to be the company's representative. So who is going to be the complainant, who is laying the case from the company side, and then who is going to be the chairperson. I'll get into a little bit more detail about that as well in this video, but for now, those two bits of information I don't think are crucial to the hearing taking place, but they definitely offer some extra useful information for an employee to have. The next purpose of a disciplinary inquiry is to make an employee aware of what their entitlements are, either before, during, or after the disciplinary inquiry. So to conclude and summarize what the purpose of the notification to attend a disciplinary inquiry is, it's to inform an employee of when the hearing is taking place, the date and the time and the place so that they can attend, to inform them what the hearing is about so that they can prepare, and to maybe give them some extra information if you want to in terms of who's going to be present in the hearing, who's going to chair the hearing, who's going to be the company's representative, but then also to make them aware of their entitlements and their rights. And that's it. Now for the remainder of this video, I'm going to go over all of those points and explain a little bit more detail surrounding them. The first thing that I want to discuss is when should you issue a disciplinary inquiry to an employee? And I don't mean that in the sense of when they've committed an offense or you're alleging they've committed offense. I mean time-wise. When prior to the hearing do you issue that notification to an employee? Often I will hear people say, the law says I get 2 days before a hearing, or employers will say to me, the legislation says I must issue this notice 2 days before the hearing takes place. I would like to just explain, because that isn't necessarily the case. And I do believe that sometimes unfairness or inefficiencies can take place when we don't understand the nuances or the things surrounding what people commonly refer to as the law says this. So first things first, these are the labor legislation books. When somebody says the law says that you need 2 days, you will actually not find it in any of these. So you will not find that specific provision in any of the labor legislation books. So technically the law doesn't say that. However, there is a generally accepted rule that an employee should receive a minimum of 48 hours notice prior to a disciplinary inquiry taking place. The reason I'm making that differentiation is because the fairness tick box will not necessarily be a measure of was there exactly 2 days given to an employee. Sometimes it might be fair to give an employee longer than 48 hours, or sometimes it might not be unfair to give an employee less than 48 hours. So my recommendation would be to take it as a general rule that you want to give an employee a minimum of 48 hours, but to also bear in mind that sometimes it might be appropriate to make that time frame longer or shorter to ensure the fairness principle, and that is that the person has sufficient time to prepare for the disciplinary inquiry. When I would recommend that you give more than 48 hours notice is, for example, when a specific offense or alleged offense has a lot of information surrounding it. So a lot of evidence pieces, a lot of witnesses, a lot of complexities around it, and an employee might need more time to prepare. I have seen a few cases where a company suspends an employee for 3 weeks to 3 months, and then they investigate the alleged offense in that time. They gather information, they chat to witnesses, and then they issue the employee with a notice, and they only give the employee 2 days to prepare. But they've had 3 weeks to 3 months to prepare and to put together all the information. So if there's a lot of complexities and the employee needs to gather information or discuss it with witnesses or anything in order to properly present their side, I would recommend allowing them more time. Allowing an employee more time to prepare is easier because it meets the minimum requirement of 48 hours because you're allowing them a longer period. So when would I think that it is still fair? The first case would be if an employee wants less than 48 hours notice. For example, there have been cases where employees would like to get their hearing over and done with. They do not want to wait 2 days before attending the disciplinary inquiry, and they request that the company do it as soon as possible. In those cases, if the employee doesn't want 2 days notice and the company can practically arrange the hearing to take place sooner, in that case, I would deem it to be fair to not give that notice. There are other exceptions or other circumstances that I would deem it to be fair, even though 48 hours notice isn't given. I'm not really going to give practical examples for fear that it's taken at face value, because they really need to be the exception to the rule if that's done. And if your case does go to the CCMA and there is an alleged unfair dismissal, unfair labor practice, whatever the outcome of the hearing was, you would need to have a very good reason why you deviated from the minimum of 48 hours notice. So my tip to employers and managers, as a general rule, give 48 hours. If you think it is appropriate to give a longer period because there's complexities to the case, then give a longer period, and only in exceptional circumstances or at the request of the employee, give a shorter period. Now, a quick word for employees. If you do receive a notification and you feel that you do not have sufficient time to prepare, or the hearing is scheduled on a time or a date where you don't think that you're able to attend, please request this as soon as you are aware of this to the manager or to the person who issued you with a notice, and request that they give you more time or propose a date and a time when you think you will be available for that disciplinary inquiry. A little recommendation that I'd like to make to employees here is when you receive the notification and you are outraged at the time frame that was given to you, meaning you think that you should be given a longer time frame, even if you are experiencing a lot of anger and outrage at that, I would recommend that you use polite language in requesting that that hearing be moved to a later date or propose a date and time that is more suited to you. The reason that I'm saying to use polite language in the form of a request and not saying it as an outraged demand to the employer is that, in my experience, somebody is more likely to grant you something if you do pose it as a request to them as opposed to a demand. I would also recommend adding in why you would like to have an extension if it is that you need more time to prepare, or if a particular witness is not able to attend the disciplinary inquiry on that day, or if your representative is not able to attend the disciplinary inquiry on that day, or if you're not able to attend it on that day, just to provide the company with reasons to substantiate your request in the hope that they will move it. And then from the company's side, it's likely that if the request is reasonable and practically they're able to move it, they most likely are going to move it. And if you've posed it as a request and you have offered good reasons why you think that it should be moved, and the company has responded and they say they're not going to move it, and they've not provided you with reasons as to why they don't want to grant you this additional time, or why they're not willing to have it on a different day if you're not available, that may impact the fairness of the disciplinary action that is taken through the hearing. So be it if it's a dismissal or if it is a type of a warning or a different disciplinary sanction, then that would be classified as a labor practice. I'm not saying that it's going to render it unfair completely. I'm saying that it is likely to impact the fairness, specifically the procedural fairness. Now I'm going to talk about the charges that are put on the disciplinary inquiry notice. The point of putting the allegations or the charges on that notice is so that an employee can prepare for their case. Importantly, I would like to recommend to employers and managers, please do not be vague when you state those charges. Please try to be as descriptive as necessary for any person looking at that to clearly understand what it is referring to. An example of a very vague charge would be just stating they're not following the company's procedures. That is incredibly vague and can literally refer to a number of different things. I would recommend saying not following the company's procedures in that you did not do X, Y, and Z on, and then put the date that the incident occurred as well. In labor, there's no catching somebody out. A chairperson needs all of the information, and it is more beneficial to a hearing that an employee have the proper time to prepare than somehow withholding information thinking that it will contribute to the hearing. It won't. If you're going to be vague in the charges, meaning maybe you don't know how to describe it, or maybe you don't feel like describing it more extensively, then take that time to explain to an employee what the hearing is about. So even if you're going to just put on there not following the company's procedures on Friday the 10th of whatever, then take the time to explain to the employee when you issue them with that notification what specific procedures they did not follow on that day so that they can come prepared to the hearing. I might say this a few times in this video and probably in other videos, but I don't know how else to phrase it other than that in labor we don't catch out employees. And what I mean by that is, in a disciplinary inquiry, as a chairperson, you want all of the information to make a proper decision. Because should that case proceed to the CCMA, it's pretty much a redo of the hearing. So the information you didn't have in the hearing could come out at the CCMA, and that might result in the commissioner at the CCMA coming to a different decision than the chairperson. And you want to avoid unnecessarily having that scenario play out. So it's more important that a chairperson have all of the information they need to make a proper recommendation to the company around what they believe the appropriate outcome should be. So to contribute to the purpose of the hearing, and that is to make an appropriate decision, just please add all of the relevant information under a charge. I have, unfortunately this has not happened in a while, but I have had scenarios where I need to postpone a hearing where I've gone all the way there, we've started the hearing, but then I need to postpone it because an employee says that they don't understand what the hearing was about and they didn't have time to prepare because they didn't understand what the hearing was about. And if I look at the charge sheet and it's incredibly vague and there's no witness to explain to me or to testify that they were given sufficient information to prepare, then it would be my recommendation to postpone that hearing. On the other hand, I've also done hearings where an employee says that they could not prepare for the hearing because they didn't understand the charges. Remember, as a chairperson, that's one of the questions that I ask. do you know what this hearing is about? Do you understand what we're going to talk about? And sometimes an employee will say to me, this doesn't happen very often, but it has happened. An employee will say to me, no, I don't understand. If I look at that notification and it's written in very plain language and it's quite clear to me, even though I literally know nothing about the incident that's occurred, because when I go chair a hearing, I don't know anything about it, and I can clearly see what it is referring to, in those cases, I might not postpone the hearing. So that again is just a recommendation as employers to prevent a wastage of resources in the form of hearings needing to be postponed. And if you're paying for an external chairperson, the resources that go into that is to just clearly state on the notification what the incident is that occurred. My recommendation is to use language that is easy to understand by pretty much anybody. I can make a whole video on how to phrase charges, and I probably will make a whole video on how to phrase charges. But just for now, the important things that I want to say is firstly, focus on the behavior of the employee, on the rule that was broken or the standard that wasn't adhered to as the primary part of that charge. And if you want to include consequences or outcomes of that behavior, you can do so, but only add it to the charge as opposed to making it the charge, because an employee defends their actions, their behavior, something that was in their control. Then I recommend, more important than using the right categorization or classification of the offense, it's more important to describe what happened. So if you don't know the fancy terminology for what happened, just write out what happened rather than using a word that you're not really sure, is this the right word to describe what happened? It might potentially assist with drafting charges. So I have linked down below my guide for managers and employers that includes 65 different offenses. And obviously I use their correct names. So it might give you an idea of how to categorize that offense. But the categorization, although it is helpful, the more important part is just simply describing what happened. And when I say categorization, what I mean here is saying, for example, it's insubordination or it's negligence or it's dishonest conduct, what kind of misconduct it was. And on that note, please don't put misconduct as one of the charges. If an employee has been invited to a disciplinary inquiry, by definition, there's alleged misconduct that's taken place. When a manager or a supervisor, whoever, issues an employee with a notification to attend the disciplinary inquiry, I do recommend that you explain to them the incident that is going to be discussed, but just bear in mind to not start debating it, to not start having a conversation about did it or did it not occur, because you're just informing them and you're checking whether they understand the incident that it's referring to. You're not having a debate then and there about whether or not it happened. But when I say that, please do not disengage from any questions an employee might have. And that often does happen where managers simply say, no, I'm not going to talk about anything now, we'll talk about it in the hearing. But sometimes their questions are relevant and need to be discussed prior to the hearing. So for example, if they don't understand the incident that it's referring to, or they need some information from you to be able to prepare properly for their hearing. Those are the types of questions you do want to answer when you issue the notification, but just don't debate the nitty-gritty of the alleged offense. When you're presenting an employee with a notification and you're discussing more or less the incident that has occurred, an employee might ask you, what proof do you have that this happened? So essentially they're asking you, what proof are you going to show in the disciplinary inquiry? Again, I just want to stress this, that disciplinary hearings are not like the kind of lawsuits that we see on TV where you catch out an employee by suddenly presenting information that, just popped out of nowhere. An employee needs to be able to prepare. And if evidence is presented in the hearing and it catches an employee off guard and they need time to process that information and come back, there's a high likelihood that that hearing might be postponed and continued on a different day. So my recommendation, although it's not necessarily a requirement, but my recommendation is if the employee does want to see the video footage or wants to see the particular evidence that's going to be shown in the disciplinary inquiry, I don't really see a good reason to withhold that information from them, especially if it's going to result in inefficiencies in having the disciplinary inquiry. So when a disciplinary inquiry takes place, employees don't really get off on technicalities, or you don't need to be good at cross-examination to be able to back somebody into a corner. None of that stuff is relevant properly in a fair hearing that takes place. As a chairperson, it is my job to ensure that I gather all of the information that if there are questions that are not being asked, that I'm going to ask them. If there's something that's being disputed, but it doesn't come up, I'm going to check whether it is or isn't relevant to the case. And mostly that is because I want to make what I believe is a fair decision in that hearing and not have it go to the CCMA where other information comes out and that would have potentially changed the decision that I would have made in that hearing had I have had that information. Most of that was aimed at managers or employers who are issuing a notice to an employee. So I just want to say a quick recommendation to employees, or rather a plea to employees. And that plea is to please prepare properly for your disciplinary inquiry. When you are issued with that notification and you don't understand what the hearing is going to be about, or you need more information prior to the disciplinary inquiry, please request that information prior to the disciplinary inquiry starting and make sure that you gather all the information that you need, get together all the witnesses that you need to get together, or do anything that you need to come and to properly defend yourself against the allegations. And that plea is because your job can potentially be at stake when you go into a disciplinary inquiry. And for that reason, I recommend employees be very prepared. Now that's all I want to say about charges in this particular video, and I'm going to move on to a slightly lighter topic now. After you've stated the charges or the accusations or what the hearing is going to be about, I recommend that after that come the details of the disciplinary inquiry. So what time it's taking place, on what date, and where. The where does not necessarily need to be the workplace. However, if it's practical and you can have it at the workplace, that might be prize number one, but it does not need to be. If it is going to be somewhere else that's not the workplace, then I would just recommend that you check that the employee is able to get to wherever the hearing is going to be held easily. The where can also be online. You can do a disciplinary inquiry where one or more of the parties joins in via a video call. And then, like I said, it might be nice to include who is going to be the chairperson. A chairperson, and again, I'll make a video entirely dedicated to what the requirements are when you get a chairperson, but it does not need to be an external person. It can be, but it is not a requirement. If on the notice you use a specific labor relations company, so you don't know which chairperson they send on which particular day, you can also just put the name of the company there as opposed to putting a particular chairperson's name, because sometimes that might change at short notice if a company has a bunch of consultants that they send out to do the disciplinary inquiries. Otherwise, if you know the name of the chairperson, it might be helpful if you just include that on the notice. Another nice to have is including there who will be the complainant, so the company's representative. This just gives the employee an indication of who's going to present the company side. This isn't a requirement, it's just nice to have information. And that covers everything that I would put on the first page of my notification. Now moving on to the second page of my notification. The second page of my notification details an employee's rights and entitlements. I'm going to go over them, and employers, I recommend that you do include these on your notification. Aside from knowing what your rights and entitlements are, the reason I think it's valuable for employees to watch the rest of this video is to get an understanding of what is standardized to a disciplinary hearing taking place and not about your specific case. So often employees who have been called to a hearing will show me their notice and they will have strong questions about the information contained in there, like, why is this here? This doesn't relate to me. It is because a lot of the time, some stuff might relate directly to you, but I'm going to share with you the information that just should be on all notifications and it's not personal to your specific case. So for employers and managers, you can either just copy what I say in this video onto a notification, or you can purchase my disciplinary notice that is linked down below. The first entitlement that an employee has is they have the right to be present at their disciplinary inquiry. So they have the right to attend and be present at their disciplinary hearing. This might seem incredibly obvious, but it is still their entitlement, and I'd like to explain, just because it's an employee's entitlement to be present at their hearing does not mean a hearing cannot take place in their absence. And that's the second thing that I recommend putting on your notice, is to explain to an employee that should they fail or refuse to attend their disciplinary inquiry, it may be held in their absence. Now I say it may be held in their absence, and I'm not necessarily recommending you automatically have a hearing in an employee's absence if they don't show up on the particular day. There are exceptions to this, and there are times where I would recommend postponing it. versus just having the hearing in the employee's absence. But the important thing to say on that notification is that if they don't attend, then there is the possibility that the hearing might be done in their absence. My recommendation to employees when it comes to this point, if you know that you are not going to be able to attend your disciplinary inquiry, please let the company know as soon as you become aware of this information. If you are not able to attend, I recommend letting them know that you're not able to attend, but then also letting them know when you will be able to attend so that they can gauge whether if they just postpone it by another day, or will it be another week, or will it be another month? But just to give an indication of, yes, I can't attend on this day, but I can attend on these days. Otherwise, if you don't communicate this information, there's a high likelihood that your hearing might be done in your absence and the decision will be made solely on the company's version of what they believe happened. This next one is a personal request to employees. If you don't plan on attending your hearing, meaning you are able to, but you don't want to attend your disciplinary inquiry, please also let the company know, because as a chairperson, there have been quite a few instances where I will drive somewhere and I will sit there and I will wait for a period of time for an employee to arrive for their hearing, only to have them not arrive, and then I do the hearing in their absence. Sitting there waiting for an employee to show up to their hearing where they clearly decided that they're not going to come to the hearing is not a good use of my time, and I would rather spend that time doing something like making these information videos. So that's just a personal request from my side. If you know that you don't want to attend your hearing, just send a message to the manager or an email saying, no thank you, you can proceed in my absence, I don't want to come. Of course, I would recommend that employees attend their disciplinary inquiries, but I also understand sometimes people don't want to sit through them. So if that's the case, please just say so. The second right or entitlement that an employee has is an employee has the right to be represented by a fellow employee or a trade union representative. A trade union representative is another word for a shop steward. So if you are part of a trade union and you have elected a shop steward, that person is allowed to represent you in a disciplinary inquiry. If you are not part of a trade union and there is no shop steward, you can be represented by a fellow employee. As you can hear, this right to be represented is limited to somebody within the organization. A company may, at their discretion, decide to grant you the opportunity to be represented by somebody outside of the company, but in my experience, this is rarely granted. Of course, you can request it and you can explain why you would like to be represented by somebody else or somebody outside the company, but an employer does not need to grant that to you. If you are going to, as an employee, be represented by a fellow employee or a trade union representative, please make the employer aware of this when they issue you with the notification so that they can arrange for that employee to be available. It isn't an employer's responsibility to ensure that your representative is available, so just remember that you need to take the steps to ensure that they are available at the time and the date when the hearing is taking place. I'm mixing in this video a lot of you. Sometimes I'm speaking you to employers and sometimes I'm speaking you to employees. So just be clear, it's an employee's responsibility to ensure that their representative is present at the hearing. However, I do recommend they communicate this to the company so that the company can do what is practical to hopefully ensure that that person is available for the hearing. Third right or entitlement. If the hearing is going to be conducted in a language that the employee is not comfortable with or does not feel that they can proceed with a hearing in that language, they have the right to a translator or an interpreter. On my notifications, and I do this because I really think it serves a practical purpose, there is a space where an employee can insert their preferred language. If we know what an employee's preferred language is upfront or what they're going to request the language be in the disciplinary inquiry, then an employer can take steps to ensure that that is available in the disciplinary inquiry. There's two ways that you can do this. The first one is if you get a chairperson who's able to speak the language that the employee is requesting the hearing take place in. In my case, I can only speak two of the South African languages, so if it's not one of those two, then a translator will need to be present in the disciplinary inquiry. But also, for example, so I speak Afrikaans fluently. If I chair a hearing in Afrikaans, but the company representative or witnesses are not able to speak or understand Afrikaans, we might be able to conduct the hearing in the language that suits the employee, i.e. Afrikaans in this case, but still need to have a translator or an interpreter present to ensure that the witnesses or the company's representative understand everything that is being said in that hearing. Now, when I say translator or interpreter, I don't actually mean a professional translator or an interpreter. It can literally be anybody who can speak both the languages that need to be spoken, who can sufficiently understand and speak the language to translate from the one to the other and then back. The other reason why I recommend having an explicit section on your notification where somebody can put their language preference is a practical reason. A hearing where a translator is needed takes a lot longer than a hearing where a translator is not needed. It literally might take double the time because every single sentence will be translated. So it will be sentence, pause, translated. So you can see how that will take quite a bit of time. And if you know upfront that that is the requirement for the disciplinary inquiry, then everybody involved can plan for that. The fourth right or entitlement is that an employee has the right to present their case and to present any witnesses or evidence that they think is relevant to their case. This, of course, is the main reason for a disciplinary inquiry, is to give an employee a fair opportunity to state their case. So this is just reminding employees that they need to bring their witnesses and all of their information, and during the hearing, they will be afforded the right to discuss their case, to discuss all the relevant information, and present any witnesses or relevant other types of evidence. And then just a reminder that it is an employee's responsibility to ensure that their witnesses are available and willing to testify in the disciplinary inquiry. So just because something is a right or an entitlement does not necessarily mean it's the company's responsibility to make sure that it happens. An employee is afforded that opportunity, but if they have not organized to have the evidence there, and it would be unreasonable to postpone it, to wait for it, or if they've not organized for particular witnesses to be there, then that responsibility does fall on the employee's shoulders. The fifth right or entitlement, that is that the employee has the right to question the company's representative or the complainant and or any of the witnesses that the company brings to the hearing. This is commonly referred to as cross-examination. I don't commonly refer to it as that because that kind of does make it sound like it's a court of law. So it's just essentially disputing anything that you don't agree with that the company has said, or asking for more information, or if there's claims that you would like to understand more, asking all the questions around that. A recommendation that I would make to employees is to write down all of the questions that you want to ask prior to attending the disciplinary inquiry. Some of them, once you've heard the company's version, might not be relevant, but it does help to prepare in the form of questions that you would like to ask. Of course, stuff will come out in the hearing that you might want to ask other questions, and that's perfectly fine too. It's just my recommendation in terms of being prepared and not having the pressure to think on the spot and to try and remember everything on the spot. Number 6, and this is the final one, and it is only applicable if the hearing has taken place and based on a balance of probabilities, the chairperson has found that the employee is guilty of the alleged offense. Only then will the employee be afforded an opportunity to present any mitigating circumstances. So these are any factors that could potentially lessen the severity of the disciplinary action that is taken if an employee is found guilty through a hearing. It isn't necessary and it's not always on notifications, but something an employer might want to include is just telling an employee that afterwards, if they go through the entire hearing and they believe the disciplinary action was unfair, either in terms of the actual disciplinary action that was taken, so the substantive fairness, or the procedure, if they believe it is unfair, they can refer the matter to the CCMA, and depending on what the outcome of the hearing was, they will have 30 days or 90 days from receiving the outcome to take the matter further. That can either be on the notification to attend, or you can just rely, like I do in my case, because when I chair a hearing, I say this to employees, so you can rely on the chairperson to inform the employee of their rights. Then to conclude the notification, I do a few more things and then I'm going to conclude this video. I like to put this on the notification to remove any mistrust that there might be around an employee receiving a notification, because sometimes an employee will receive a notification to attend a disciplinary inquiry and they will refuse to sign it, which of course they can refuse to sign it. However, I just put on there what it means when they are signing it, just to try prevent unnecessarily refusing to sign it. And what I mean by that is I put on there that by signing this notification, you are not admitting guilt to the alleged offenses. Obviously, I don't use this exact wording, but you are not admitting guilt to the alleged offenses. By signing this notice, you are simply confirming that you received it. And the reason I do that is because I think sometimes employees might think, if I sign this, I'm signing that I did do whatever they're alleging I did. And that isn't the case. At least when you receive my notification, that's not the case. The case is simply that you're being notified of your disciplinary inquiry taking place. But because I understand that employees might refuse to sign a notification, I do recommend to employers that when you issue a notice to an employee, to do so in the presence of a witness. And that if the employee refuses to sign the notification, that you have the witness sign it to testify that the employee did receive the notification and that it was issued to them properly, meaning they were given an explanation of everything that is on that disciplinary inquiry notice. The final practical thing that I do is I ask whoever's issuing the notice to kindly write their full name on the notification. A lot of the times on these types of documents, there will only be a signature, but there won't be the person's name. Now, I can't tell who issued it simply by somebody's signature, but if I have their name, then if I need relevant information, I can ask for that person. And what I mean by that is if an employee claims that they did not receive the notification, I can ask the person who issued it if they did. Or if an employee claims that they did not understand what the notice was about or they didn't understand what their rights were, again, I can ask the person who issued that notice. So if you have a notification to attend, I recommend that whoever issues it writes their full name on that notification. And that concludes a whole bunch of information about issuing a disciplinary inquiry notice to an employee. I hope that this video was helpful for you. If you want to assist me in continuing to bring you this type of content, please remember to subscribe to my channel, like and comment or engage with any of my videos. That's helpful for me.